Hello, I'm Elizabeth Blair. My practice is Blair Law. I'm a solo up in Napa, California. My practice focuses on mostly real property issues as well as litigation, probate, and trust matters.
And I'm Brian Manson. I'm Assistant General Counsel with the California Association of Realtors, one of the leading trade associations in California.
So we're here to talk about liability arising from electronic signatures. So having a signed contract has always been part of the prima facie case to prove that a contract exists. And so we're going to talk about the enactment of the Uniform Electronic Transactions Act and e-sign. So the Uniform Electronic Transactions Act or UITA, was enacted in 1999, and its goal was to enable parties to conduct transactions electronically. It doesn't require it, but it just allows a framework for those transactions to take place.
And in 2000, the U.S. Congress passed the Electronic Signatures and Global Commerce Act, the e-sign Act, which technically supersedes any state laws, but only to the extent they're inconsistent. So what do the UITA and e-sign Act require?
So basically what they require is they require that attribution. So a party has to, the party who is electronically signing a document, it has to be attributable to that party. Mm-hmm. And then it also provides that the party who is electronically signing that document has to be able to obtain a record and keep a record. And if the party can't keep a record, then that transaction is technically invalid under UITA.
That's right. And neither the federal nor the state law require the parties to do business electronically. Instead, if the parties agree to do business electronically, and that can be by some sort of affirmative act, or it can be by the conduct of the parties, such as doing an online transaction, that's sufficient to show they agree to do business electronically. And then the laws say that the fact that a record is electronic, it can't be used to invalidate the transaction. A transaction is not invalid just because a particular record in the transaction is electronic, and the contract or other agreement or action of the parties is not invalid just because an electronic signature was used.
Right, and not only that, but an agreeing to conduct one transaction electronically doesn't require or provide that consent for future transactions. So that party would then have to agree again to conduct another transaction electronically. So that first consent to that initial transaction doesn't allow for the second transaction. It has to be a second consent to conduct business electronically, which could come up in the commercial setting.
Right.
I see that.
Yeah. And it's also important to note that while UITA and the e-sign Act apply to almost all transactions, there are a few exceptions in the laws, and those include most commonly trusts, wills, and codicils, some applications in the landlord-tenant context, certain notices, and in the foreclosure context. These sorts of records can't be, an electronic record is not sufficient to serve as a contract or notice in some of these areas. And so you should check the code very carefully. Do you have the code citation?
Yeah, so the UITA is California Civil Code section 1633.1, and that sequence, I think it goes all the way up to 1633.15. And then e-sign is codified at 15 USC 7001, and that sequence.
Right.
And so the court in the fourth district in 2014 held in Ruiz versus Moss Brothers. This is a really interesting case because basically what it held was that in the employer-employee context, an employee couldn't be held to an arbitration agreement that was contained in the various employment documents that I think we all signed when you start work someplace. And even though the employee had already consented to a number of different arbitration clauses in a number of different agreements, the Moss brothers, the employer, couldn't demonstrate that this employee, Ruiz, actually signed the arbitration agreement at issue in the case, because they just basically said, well, it's my the HR manager basically said, well, it's our common practice to have our new employees sign all of these documents. And in this particular case, that generalization wasn't strong enough.
That's right. The court seemed to want the defendant to prove that the employee had actually signed this document. And so there are a couple of ways to prove when somebody signs a document. For example, you may represent a client who's repudiating a contract saying they never electronically signed it, or perhaps they're dealing with the other party repudiating a contract. One very valuable tool with electronic signatures on documents is the audit trail. An audit trail on a electronic record is a record of who created the record, where it was sent for signature. It'll have a lot of details. It'll have an email address where it was sent. It'll have the method that was used to authenticate the signer, whether they used knowledge-based authentication or two-factor authentication, or perhaps neither of those applied and it was just sent to an email address. It can track the IP address where the signing link was picked up, the time that it was picked up, and when that user committed their signature to the document indicating their consent to their signature on that document, as well as backtracking. Usually at the start of that, they'll also capture the consent to do business electronically. So all those things can be important, and those weren't present in the Ruiz case.
Right.
And so as you say, the court said you can't just rely on a business practice. That's not enough to authenticate the signature on the arbitration agreement.
Right. So the employee, Ruiz, was not compelled to arbitrate that claim because they failed to authenticate that his signature was actually his signature. And I think it's really important, especially when you're looking at, how this applies in your own practice. If you use electronic signatures in your attorney-client fee agreements, if you're representing a husband and wife or something like that, how are you going to demonstrate if they come back and say, oh no, I didn't sign it? How are you going to authenticate that that husband and the wife both signed the agreement? So different email addresses,
Right.
potentially different computers so that there's different IP addresses, looking at the time. I know, Brian, you've dealt with something at CAR where where there was a girlfriend or something who tried to say that somebody signed and.
Yeah, we had a couple of interesting situations. This one came to us from the DRE. A man had said he didn't sign an agreement, and through looking at the audit trail, they were able to determine the contract was sent for his electronic signature at his normal email address. It was picked up on his home computer and signed, and it looked like he might have signed it. However, through the detail in the audit trail, they were able to determine it was actually signed while he was at work. And so then the question, they figured out that most likely his live-in girlfriend may have picked up the email, gone and signed the contract for him. And then it became a different issue. It was no longer whether the document was actually signed by somebody there, but whether he had given consent for her to sign on his behalf.
That's a whole different issue.
A whole different issue. And that kind of issue can exist in paper contracts with wet signatures as well. One other interesting situation we had involved someone who claimed that they didn't sign a particular real estate disclosure, that they had never gotten it, and they were suing their agent for not disclosing something that had been included in a disclosure. In looking at the audit trail on behalf of the agent, we were able to determine that that disclosure had been included with about 4 other documents that the man had admitted he signed. He said, yes, I signed those, but I never saw the disclosure. Well, through the audit trail, we were able to determine that it was all created in one signature session, went to him as one packet, that all were signed within minutes of each other, and the case very quickly settled after that because he didn't really have much basis left to deny signing the agreement. So things like audit trails, authentication of your signer, these are really key aspects of electronic signatures that you'll use in your practice on behalf of yourself and your clients.
Yeah, absolutely.
Thank you very much.